All right, good morning, everybody. Today we're going to go over the buyer agency contract, buyer tenant agency contract. In addition, we're going to talk about door knocking at the end of it. But to kick it off, we're going to jump into this contract here and go over a few things that have constantly come up over the years as far as issues with people not filling out this contract exactly properly. So to start it off, I'm going to go over some of these highlighted sections that I put together to save us some time so we can fit it all in. So the first part I'd like to talk about is this highlighted section in green. Buyer understands that this buyer agency contract is between broker and buyer. Does buyer have a buyer agency contract with another broker? So make sure you guys are filling this out. This is important in determining, an unbreakable chain of events that, basically awards you compensation if there's a push comes to shove over that fee to be paid. So scrolling down here, getting into the starting and ending dates, no association of realtors has set forth or recommended the term of this contract. Broker, licensee, and buyer have discussed and agreed upon the length of the term of this contract. Broker may be paid a fee that is a percentage of the purchase price. Even though broker's fee or a portion of it may be paid by seller or listing broker, broker will continue to represent the interest of the buyer. This contract applies to any property that the buyer chooses to purchase during the term of this contract. Buyer will not enter into another buyer agency contract with another broker / licensee that begins before the ending date of this contract. This is important because that encompasses any property that the buyer looks at, whether it's a for sale by owner or a property listed by a listing brokerage. You've got your starting and ending dates. The contract starts when the buyer and broker sign, unless otherwise stated here. If you want to have an extended starting date, that's obviously where you would fill that date in. The ending date of this contract is where you fill that in, and that's going to coincide with your expiration date in the MLS. So sliding down to the next paragraph, number 2, broker's fee. No association of realtors has set or recommended broker's fee. Broker and buyer have negotiated that fee. The fee broker will receive for exercising professional knowledge and skills in locating and assisting buyer in the acquisition of real property, which is available and suitable for the buyer. Part B, broker's fee paid by buyer to broker is as follows. In a purchase transaction, with a seller represented by a real estate broker, the fee is a percentage of the purchase price or a fixed dollar amount, whichever is greater, and a additional fee thereafter. This fee can obviously be higher than whatever is listed in the MLS, and we'll get to that part here later. But it's very important to obviously fill these out. With a seller who is not represented by a real estate broker, this fee is, again, a percentage of the purchase price or a fixed amount, whichever is greater, and an additional fee as set forth in that spot. There's a section here, if you are in a lease transaction, you can specify, whatever fee that you guys negotiate. The important part of this is spot 3, and this comes into play because a lot of people feel that they shouldn't fill this out because fees are commonly paid by the listing brokerage and the seller. But this states, it is the broker's policy to accept compensation offered by the listing broker. If the amount received from the listing broker is less than the amount in paragraph 2B1, in a purchase transaction or 2B2 in a lease transaction, buyer will pay broker the difference unless the seller agrees to pay the difference as a term in the agreement of sale. So obviously, when you submit a contract, like I said before, if the fee that you quoted the buyer here in the buyer agency agreement, if that is less, or if that's more rather than what's stated in the MLS, that responsibility to pay that fee is by the buyer, unless you negotiate that with the listing brokerage before you submit that contract.
Brooks,
Yes.
Okay, question. So the way that I'm reading number 3 is if number 3 is less than number 1A, then they have to pay whatever is on that MLS broker, right? Is that what you just said?
Yes. So essentially, if you quote somebody here in 1A that you're only going to work for 3% and a $4.95 fee in there, if the MLS states that, you know, the listing's only offering 2.5%, buyer is then responsible for the 0.5% plus that additional fee that you quoted, $4.95.
Okay, so
Does that
in theory then, even if this is left blank, because this says number 3, that the buyer would be responsible to pay at least the commission that's in the MLS, even if you forget to put like you left this blank, right? 0%. Number 3 basically states that they still have to pay you the percent that's listed in the MLS should they walk away from this deal.
So you're going to be paid whatever's in the MLS, but the problem lies in, what if it's a property that's only $45,000 and you're not willing to work for, let's say it's a discount brokerage and they're only listing 2% in there.
No, what I'm saying is, what happens if someone walks away from the deal? The buyer walks away from the deal. Doesn't this technically then state that the buyer would still be responsible for paying the commission?
If they breach contract, but that actually comes into play here later in this section that I highlighted in yellow.
Okay.
Well, let me ask you a question then, Stacy. Why would you not want to fill in?
I don't know. I would want to, but I'm just saying we had a situation where it was missed in the
Okay.
contract. And so
that's the
I'm
reason,
reading
yeah.
this thinking, could we have gone back and gotten that commission, even though we missed it in the contract? Could we have gotten that commission?
No, the reason why, Stacy, is that paragraph, what is that? 3, right? That is, let's say in the MLS, it says the seller's willing to pay 3%. Okay, your buyer backs out, you head down 0% there. Okay, well, the list side isn't going to pay you because there is no deal that came to fruition. And the only way they would pay is if there was an actual settlement. So if the buyer backed out, then you have to collect from them whatever is in B. And
Correct.
if B is 0, then you can't collect anything from
Can't collect anything. Okay.
Yeah. That, I think that's what you're trying to allude to there. So
Yes.
yeah. Yeah.
Exactly. Yeah. The seller's not going to pay a fee if their house didn't settle. So you can't collect anything unless it was represented in 1A or 1B.
And the reason that I wanted to do this form today was because number 2B, 1B is the spot that most people are forgetting to fill in. That if their buyer turns around and goes and buys it for sale by owner. So whenever I get those phone calls, I always ask for a copy of this agreement when I hear that they went and bought it for sale by owner, you know, and now do they owe me the commission? Well, they only owe you the commission if you filled in number 2B, 1B. So
Exactly.
don't, right, so don't forget to fill number B in also, the same as number 1, or whatever terms you want to put in there.
So it's not stating on 1A, it's not, initially when you read it, it sounds like it's stating even with a seller represented by a broker, the buyer is responsible for 3% or a certain amount. So it makes it sound like,
You could get 3%.
it makes it sound like they're gonna be charged 3%.
And they are, Stacy, they are going to get charged. If you go show a house right now and it's in the MLS, that buyer owes you 3%. However, because you are compensated 3% for the deal. However, the seller is offering that 3%. So then the buyer doesn't have to pay it. If the seller's not, and I've seen some lately where the seller is only willing to pay $100, then the buyer is responsible for whatever the difference is.
Which
Okay.
is stated in that part 3.
Yeah, Brooks is going to go over that next.
Because, yeah, in number 3, it says if the broker's policy is to accept compensation offered by the listing broker.
Right. Unless it's less than, the
So
listing.
those two pieces, we have to be sure to explain that it's not one or the other. It's not that we're saying, because we've had buyers who have said, well, I don't want to be charged 3% in addition to. We have to explain that if A is filled out, A only takes into play if 3 is kicked in gear.
And Stacy,
Exactly.
here's how I explain it. I say to a buyer, my commission is 3% to represent you, whether it's a house in the MLS or a for sale by owner. Any property you buy during this period of time is 3%. Now, most of the times, the seller will compensate me, but if there is a difference, you're responsible for that difference.
Okay.
Okay.
Sorry, we've had
That's
some
okay.
issues with my team on this one, and I know they're gonna ask me about it today.
Sure. Alrighty, guys, if we don't have any other questions on that section, we'll move to paragraph C here. And this states the balance of the broker's fee is earned if buyer enters into an agreement of sale during the term of this contract, whether brought about by broker's licensee, or by any other person, including the buyer. If buyer defaults on the terms of the agreement of sale, broker's fee will be paid by buyer to broker at that time. So Stacy, that's where you were talking about if the buyer defaults on the terms of the agreement of sale, the broker's fee then will be paid by buyer to broker at that time if you have a fee disclosed and represented in paragraph 1A or 1B. Buyer is advised that contacting a listing broker or seller directly may compromise broker's ability to earn compensation from a listing broker and could result in buyer's obligation to pay the fee to broker. Paragraph D, this protects you after this contract. If buyer enters an agreement of sale for a property after the ending date of this contract, buyer will pay broker's fee if the agreement of sale is a result of broker's actions during the time of this contract, the property was seen during the term of this contract, and the buyer is under an exclusive buyer agency contract, or is not, rather, under an exclusive buyer agency contract with another broker at the time buyer enters into the agreement of sale. So this is the unbroken chain of events that you would have to represent if you wanted to be paid that fee after this contract expires. Anybody have any questions about this section? Okay, moving on. There's a lot of standard notices in here, but kind of going back and touching on our conversation last week about having the buyer sign something additional in regards to us advising them about inspections in that sort of thing when inspections are waived. We actually, in my opinion, have some protection for this already built into the buyer agency agreement. In this paragraph 9 here, it kind of touches on that. And then further in paragraph 13, I'll quickly read these things and then we'll open it up for some questions and then move on to door knocking. So paragraph 9, expertise of real estate agents. Pennsylvania real estate agents are required to be licensed by the Commonwealth of Pennsylvania and are obligated to disclose adverse factors about the property that are reasonably apparent to someone with expertise in marketing of real property. If a buyer wants information regarding specific conditions or components of a property, which are outside the broker or licensee's area of expertise, buyer is encouraged to seek the advice of an appropriate professional. If buyer wants financial, legal, or other advice, buyer is encouraged to seek the services of an accountant, lawyer, or other appropriate professional. This, clearly states, obviously, if they want more information about structural components or specific conditions, they need to seek an appropriate professional. Coming down here to paragraph 13, buyer inspections. Unless buyer and seller agree otherwise, real estate is sold in its present condition. It is buyer's responsibility to determine whether the condition of the property is satisfactory. Buyer is advised, in bold here, to carry out an inspection at buyer's expense by qualified professionals to determine the condition of the structure or its components. Areas of concern include, but are not limited to, and they have a long list here of, the spots that should be inspected. Buyers should discuss inspections and any special needs with the licensee. Buyer is advised that the information regarding properties considered for real estate or for purchase by buyer has been provided by a seller or seller's broker. Such information may include, but is not limited to, the information on the seller's property disclosure statement, including environmental conditions, MLS information, including information regarding restrictions, taxes, assessment, association fees, zoning restrictions, dimensions, boundaries, if identified in marketing info. Unless otherwise noted, broker has not verified the accuracy of this information and buyer is advised to investigate its accuracy. To me, again, this paragraph kind of gives us a little bit of a release of liability and puts the buyer on notice that they definitely should have an inspection carried out. Obviously, this market, it's not very competitive to have a home inspection contingency, but I think this provides us some level of protection. Does anybody have any questions or thoughts they want to share on this? All right.
I'll reserve a comment once we get done with the form.
Okay, well, at this point, I was going to move on to door
Okay.
knocking. Those are kind of the sections I wanted to go through.
All right, let me
The
then
contract.
just talk for 1 minute about this form.
Yep.
So, go ahead.
It's that exclusion.
Oh, okay.
Why?
Just gonna mute.
So years ago, before the advent of DocuSign, we used to meet with all of our buyers in the conference room and get them to sign the consumer notice and the buyer agency agreement and get them pre-qualified and do a cost sheet. And we would call that a mini session. Today, most people are not doing that. And they're literally, I would wonder what the percentage is if Seth were to look at our forms. What percentage of these forms are being signed by DocuSign, the buyer agency form, which means most likely nobody's ever went over this form with the people other than to fill it out and ask them to sign it. And if they're literally clicking through and not reading it up front, they don't know what's in this agreement, what's not in this agreement. So if you are working with buyers, I would recommend that at least the buyer agency and the consumer notice, you meet with them, you circle different things, you get them to sign it in an ink, and at least those forms are explained to the buyer, which is the consumer notice and the buyer agency, because they're two of the forms that we have the most problems with. If you're literally having this buyer agency form and the consumer notice filled out at the exact same time you're writing a contract, then you never really went over these forms with the buyer at the first substantive meeting. So my last 2 cents on the thing is, consider when you're meeting with these buyers to go over these forms in person. And as you're going down the form, like through number 1 and number 2, just put a circle on it. Because if you were to get called into the district justice trying to enforce this form, the circle just shows that you went over those sections with them. You know, it wasn't just a DocuSign form. I've been in multiple district justice hearings with this form, some of which we won and some of which we didn't win the full amount that was listed in the form. So, you know, it's a hit or miss situation, even trying to enforce it. And a lot of people don't want to enforce it today if your buyer went out and bought it for sale by owner, because they don't want the recognition through or to be slammed on Facebook or some sort of review that you tried to enforce this form that was never explained to them. So again, going back to the whole theory, have a mini session, get the form signed. That's all I'm going to say, Bruce.
Real quick too, and this is only because I've gotten questions about this, especially with the limited inventory we have right now. Section 5, broker service to others, 5B, it states that broker/license may show the same properties to other buyers and may represent those buyers in attempts to purchase the same property that buyer wishes to purchase. So I've had people ask me, are they allowed to show and make offers on the same house? Here's the section in the contract that clearly states you are allowed to do that. The other part is 8, confidentiality. Buyer understands that seller or seller's rep, listing agent, might not treat the existence, terms, or conditions of any offer as confidential unless there is a confidentiality agreement between buyer and seller. That kind of gives way that if we have multiple offers, their offer isn't a secret. If I say to the other agent, well, if you give me 236, you'll get the deal. Doesn't that make it kind of allow you to do that and shop the contract around to get your seller the highest price?
Yeah, so basically what it's saying is if you don't have a confidentiality agreement and you're negotiating it as a seller's agent, you have the ability to disclose other people's offers in order to work in the seller's best interest.
Right. It's only secretive when it's between you, the buyer, and the buyer agent. But once the buyer agent hands it over to the listing agent doesn't have a responsibility to keep that confidentiality.
So all those listing agents that tell you I can't tell you the details of that offer or line, obviously.
As Uncle Tim would say, who do you work
Gold-
for?
Yeah, Goldsmith has brought that point up, and it's a very true one, and a lot of people don't know it. But yeah, their offer technically is open to the public, and they should be able to tell you that information. Whether they're going to or not, it's a different story. But anyone else have any questions about the buyer agency contract? This
Can I
I
say
have one.
two?
Hi, Brooks. This
Yeah.
is Lee. So I have a question about 1A. So when you put
Okay.
a number, specific number in there, then you're held to that. So what do you do in the case where the MLS is typically offering either 2.5 or 3%? And if you're okay with whatever the MLS lists, how should you correctly fill that out?
So that's up to the discretion of the licensee slash broker as to whether they want to enforce, the buyer paying for that difference. If you don't want to enforce it, you don't have to. If you do, you have a leg to stand on if it's properly filled out within this agreement.
Okay,
Alrighty?
all right, thank you.
Yeah. Morgan, I think you had a question too.
I don't have a question, but more of a comment. So I always make sure that I point out too about the registered sex offenders in the buyer's agency, because actually buyers don't know that, that like we don't look into that. And especially people with kids, I feel like that is important. So that's always something that I like circle, underline, everything like that, just because it is always changing and people with kids may be concerned about that. So I think that when you are going over it, that's definitely a point you probably don't want to miss.
Yeah, absolutely. That's definitely one of those that you want to bring up in a mini session that my uncle's talking about. If you're in person where you're circling the points of the contract, you highlight that one and touch on it. If you guys, obviously there's instances where you can't meet face to face with buyers. So the way I filled this out and highlighted it, you can actually do that right within Zip Forms. So I just switched over to Zip Forms here now. If you want to highlight any section of this contract, you just select the words that you want to highlight. And so if it's that paragraph or that word, you come up to this highlight button and just click highlight. And you can make this a highlighted section of the agreement that they then can go ahead and sign. So that's another way to kind of do it digitally and give a impression to a paragraph that you want highlighted. Mr. Sath, I think you had a question too, or wanted to share some thoughts.
Yeah, thanks, buddy. Not really a question, just kind of aligning with Tim about the form. And really my comment is we don't need to reinvent the form. The form is there for us to use. So like Stacy mentioned that if things are blank, and I know things get missed sometimes, but just fill out the form completely. And I've seen some forms where if there's a white space that a licensee might add extra comments, something like a $4.95 broker fee is added, and that's fine, but you don't need to do that. The form is made for us so that we don't need to do anything extra. Just use the template as it is and don't reinvent the wheel and keep it simple, and I think we'll be good.
Absolutely. Yeah. Fill in the blanks and don't play attorney.
Right.
Brooks,
Yes.
in section 13 about the buyer inspections that you went over,
Okay.
and I know, most of us don't read it verbatim to the client, but I noticed it says about deeds there, that they can inspect deeds. So we're
Yes.
responsible to give them a copy of the deed?
So deed restrictions in zoning is one of the inspections that they can do, and that's actually a spot that they either waive or elect within the agreement of sale.
Right, okay.
So it depends on the client as to whether or not they want to inspect those areas. That's typical if they want to have chickens or something out back and want to make sure that the township allows that, or they want to park an RV at their property and make sure there's no deed restrictions or anything like that against it. Alrighty, guys, we'll wrap this up for today. Thanks for jumping on the call. I'll send out the recap. I don't have the topic picked out yet for next week, but as soon as I do, I'll send it out to you. All right, guys, have a great week.
Thank you.
Bye.